and the questioning continues, even though it is just a one-sided committee, because the MPP MPs have walked out of the committee's sitting. So let's go back to the committee room where Bernard Ahiafo is presiding over the sitting, taking questions from NDC MPs.
By a long period. All these affects people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, the District Assembly, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts, together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. And all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the report that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The other thing is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases. And that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank, and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller." And then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady." So it is his sister, it is his daughter, it is his girlfriend. So go and see her. So people give their monies to people, and then they don't even, once they have given the money out, they have bribed the judge. They have given, they are okay. So such people go about saying that, "Oh, the judges have taken their money." And once the judge has taken their money and they get their judgment, they are okay. But the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what we call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think about 2 or 3 years, for about 2 or 3 years now, we have a situation where applications that are, even applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately I became, so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot, because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce it used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Honorable Chair. I think I'm the wrongest person to ask this question, because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State, on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these 3 groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these 3 lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar, and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than 1 or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice, And so, with this kind of nomination from these three people, how people can talk about political, I can't really understand. With the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our Constitution says. If Ghanaians believe that the Constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination.
Thank you.
And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment as part of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the My mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement, in football we say, if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, you as you rightly said, the nomination and appointment and everything is done by the president. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes?
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of the current list, on the advice of the Judicial Council, 41 persons' names were sent to the presidency. And only 4 out of the 41 names were taken out. And even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on the I was pleading with the president that we needed to have these people sworn in so that the legal year the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how would I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings. Like, as I said, we mentioned the complexities of the rules. We talked about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra, and also even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then Parliament. Whilst the lower bench have their salaries tied to normal civil servants. And worst of all, the judiciary, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the high court judges, even in some regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And if before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
Chairman, that will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think, yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Sito and other things came up and said that that was right. That was it. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood. But a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, President Mahama was declared, and it was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Dankwa Akufo-Addo from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat, that would have been the order of the Supreme Court, and it would have been enforced by Article 1 and 2. The same thing would have happened in 2020, when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice?
There's no
court order restraining Parliament from processing the nomination of the president?
There's no court order.
And you are here because we have summoned you to come for us to process you?
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search, to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. But that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond, all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf. Just so that they see that we're not running away from anything and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he'll give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were